We talked to Dr. Ed Johnston, who's a senior lecturer at the University of West of England in law. We talked to him about managerialism in the law in the UK. Now, a definition of managerialism is, first, it refers to the introduction of private sector management methods to the public sector. It stresses outputs rather than inputs. Now, you might think that in a legal situation the inputs were quite important because that's like evidence. It stresses outputs rather than inputs, specific standards and measures of performance, such as what can you measure in court, timescales, conviction rates, managing by results, and, in inverted commas, doing more with less.
Ed, you were going to tell us about managerialism as well, so do tell us.
Yeah, well, it's something that's sort of really come to the fore in the criminal justice system over the last sort of 20 years or so. The criminal procedure rules of 2003 created an overriding objective of dealing with cases justly. And this definition of justly contains a number of different elements about being fair. But one of the most striking ones is hidden sort of halfway down this list of definitions, and it's dealing with the case, efficiently in an expedited manner as possible. And what has happened since 2003 and slightly before, maybe the old review of 2001, is the idea that things need to be done quickly. And it's a worry. And it's been a worry for, the last 20 years. And it's certainly something that, I've written about my PhD was based upon. And what I found from my own empirical research, as well as case law that existed, is the tone and tenor of the courts has changed somewhat over the last 20 odd years, or nearly 20 years. Basically, again, this adversarial battle between sort of prosecution and defense, arguing eloquently in the courtroom, is being diluted. And what we're having now is the idea that magistrates and judges will look at the lawyer, and if you haven't complied with, say, pre-trial disclosure or something like that,
no,
the judge would say, well, your client knows if he's done it. Why do you need any further disclosure? He knows if he's done it. And I interviewed 24 practicing defense lawyers in 2015, 2016, and almost all of them had said that there is this push to conveyor belt justice. It needs to be a smooth process, lack of adversarial hurdles, and the key finding was the tenor of the court is your client knows if he's done it, so let's get on with it. And I spoke to a lawyer.
I don't quite understand how the one follows from the other. The fact that you know you did it isn't quite the point, is it? It's somebody else has to decide.
They have to prove it, don't they? Wasn't that
exactly. So, the burden of proof rests on the prosecution and they have to discharge that. But again, It's an adversarial hurdle that's being diluted. I was talking to a practicing defense lawyer a couple of weeks ago on my own YouTube channel. And I asked her about this question about, does managerialism exist? What's the sort of tone from the court? And she gave an example of a defense witness who she wanted an adjournment in a case because the defense witness couldn't come to court because they were self-isolating due to COVID. And that got thrown out and the case had to be, or that was rejected and the case had to proceed in the absence of this key witness. The prosecution in another case made the same sort of application for an adjournment because a prosecution witness was shielding in self-isolating because of COVID. And the court said, okay, we'll adjourn for X amount of time. But if they can't turn up the next time, we're going to have to carry on. So it's just this sort of disconnect between approach to defense and the prosecution. And part of the genesis of this managerialist idea was Lord Justice Old's review of the criminal courts in 2001 and a couple of cases preceding that where he was the sitting judge, where he made some, in his judgments, he talks about how the defense or the defendant doesn't need to be given a sporting chance. It's a pursuit for the truth, and being efficient doesn't impact his fair trial rights. And the defense, for about 10 or 15 years from the case law that followed, the defense was sort of berated for not being into this cooperative idea. So a colleague and I published a book on the law of disclosure back in December. And for one of my chapters in the book, I looked at cases that have been discontinued because of disclosure failings. On which side does it rest? And it's pretty equal. But you wouldn't think it was equal between the prosecution and defense in terms of who's responsible for a failing when you read the judgments of a number of cases stemming from the early part of the millennium until today. There is a real kind of hammer being thrown to the defense that you're not doing this, and we need to be efficient and get on with it. And that isn't replicated when the prosecution fail, because they are almost equally as responsible as the defence for failures with disclosure.
So the defence are impeding the prosecution, they would be saying?
Well, yeah. Basically, this idea of conveyor belt justice is grinding to a halt because the defence aren't cooperating in this managerialist model of justice, where everybody gets on. And some of the things that, the case of Gleeson in 2004, it startled me when I read it. And you basically have a case that couldn't be proven. Okay, so at halftime, the defence submits no case to answer here. Let's dismiss the charges. The court said, no, that's going to impede justice. What we're going to do, you can't get away on a technicality. You should have raised this earlier, told the prosecution that a successful conviction is impossible. We're going to allow the prosecution to amend the indictment to make it a conspiracy to commit this particular fraud. And then Gleeson was convicted. I mean, firstly, that's an erosion of the sort of penalty shootout theory that the prosecution get one chance to convict you. And secondly, how many goes are you going to need? And why should it be for the defense, who are acting in their client's best interests? It might be a tactical line of defense, but that's perfectly legitimate in an adversarial battle. It's a weapon in your armory. If the prosecution aren't competent enough to realise this offence on the evidence advanced is impossible to complete, that's their affair.
I'm speechless.
But you had something similar in the family court.
Yeah, but yeah.
Do you want to talk about that?
Yeah, I will in a moment. But I'm still recoiling from this idea. I think it's appalling.
Yeah.
And that's what I think. Go on, sorry.
Well, I'm just an aside here, Ed, but this can only happen because ordinary people don't know what goes on in courts. That's the only thing I can think of, because I can tell you when I was doing the work, and it is a long time ago, but you had that sense that no one understood until suddenly you get a phone call from a magistrate whose son or daughter or a relative had a problem, and then they're absolutely talking a different story then. Or somebody, who has never been involved with the idea that you might get arrested. And then they suddenly realise what the system's like. But until then, they've all thought it worked smoothly, nothing went wrong, and the way that they were dealing with it was all right.
I think that's half the problem. People don't care until it's them.
No.
They believe allegations made in the media, no smoke without fire, especially around sex crimes, that this person, especially if they're a celebrity, would have done this.
Yeah.
But nobody cares or understands what happens in the police station until you're sat there, until you're the person that could go to prison for something that you perhaps didn't do, or, legitimately through intoxication, you can't remember whether you did it or not. And you're not being difficult by saying you can't remember. You legitimately can't remember. And I used to hear this, a lot from my friends in social circles of like, why are you interested in criminal defense, getting, terrorists and rapists off and things like that? Why are you advancing that cause? And my simple answer was, well, it could be you. It could
Yeah.
be me. And, this is 10, 15 years ago. We've all got children now. It could be our kids.
Yeah.
Um,
And we'd be up
People
in arms
simply
then.
don't care. Yeah, absolutely. Much like that
Yeah.
magistrate, what can you do here? How can you help me? They
Yeah.
need to do
Did you
X,
know
Y,
that
and
they
Z.
did this and this and this? And how can that have happened, to my
Yeah,
son?
yeah,
Well, it's happening to all the other people that you've been involved in sending to prison as a magistrate.
absolutely.
Anyway. No, my example, we've had with the family court, and sorry to keep going on about the family court, but we've gone through these processes where they've demanded that we do certain things within certain timescales, which is, I suppose, fair enough. Except they use reasons which aren't true to suggest that that's why we're doing it. They're not saying that we're doing it because we really want to get these cases moved along swiftly. We haven't got the time to spend on them. We don't want all this money spent on them. If they said that, I'd understand it. But we've had protocols and procedures that were put in place where decisions have to be made within a certain timescale, where you are told how long your statement can be, you are told what you can put in your statement, experts are told that they should be able to write a report within so many pages, and if they don't and they go longer, I've heard of experts being severely criticised, and they thought what they had to do was do an assessment. And I think it must be the similar kind of thing, that we don't care anymore and that let's just do these cases. Let's not do them well, let's just do them.
Yeah, it's very similar to the criminal justice system and to this idea of a conveyor belt, that things can simply pass through a particular part within a certain prescribed period of time that appears to be drawn from thin air. An expert can give evidence in, I don't know, 20, 30, 40 minutes or whatever. But that isn't dealing with things on a case-by-case basis.
Nor is it
And
fair to a family involved in a family case, or a criminal, potentially a criminal matter. I won't call them criminals because they aren't even criminals until they've been found guilty, are they? So, oh dear.
I remember reading a government document that said swift ensure justice. This must have been almost 10 years ago. And I remember opening it to my students and saying, well, I think you can either be swift or sure. I don't think you can be both. And that's the sort of process that we're operating in now. It needs to be quick. It needs to be swift. But I can't say with any degree of certainty that we are sure, and it sounds very similar in the family court there as well.
How do you think this is going to go forward? What do you think? What do you see in the in the future with this? Because clearly these are criticisms, and lots of people who've experienced it and lots of people working in the courts will know about it. But how do you think things are going to change? Are they going to get worse, or are people going to resist it? Or
They're going to get
I
worse.
don't think there's. I don't think there's going to be much resistance. I mean, we've had this idea of efficiency for quite a long time. And if you think about going back to silence in 1994, the changes there, changes with disclosure in 1996, then the criminal procedure rules in 2003, they're all sort of piecemeal kind of cuts into an adversarial process that took time to deliver justice. And what we have now, I think it's embedded in our culture on both sides that we have to be efficient and we have to be economic. When I did my PhD study out of the 24 defense lawyers, I created 3 conceptions of what defense lawyers existed. And we had the classic adversarial lawyer who, best interest of the client, forget the rules, I'm here to advance their best interests. Then there was a conflicted adversarial lawyer who said, my primary duty is to my client, but I have all these obligations to the court and I have to take part in these efficiency measures, etc., etc. And they were the most popular group of lawyers. The vast majority of them were conflicted. The final group were the operationalized, who just operated post 2003, so post the rules, and were like, well, my primary duty is to the court, to efficiency, and keeping the system running. Unsurprisingly, the classic adversarial lawyer, there was only 4 of them in the study, and they were all aged over 55.
Yeah,
So they all operated before the disclosure regime was ever created, and they're going to retire. We're going to lose those adversarial lawyers. And I think we're going to be left with the sort of operationalized idea that efficiency is fine, it's part of what we do, and that's how justice is done in the modern era.
Well, God help us then, Ed.
Well, we were very impressed with eBay. We had a situation, didn't we, where there was some
eBay.
eBay. We had bought something and
it was a fake.
It was a fake, and so there's a complaint system, and you can write in, and you get a note saying this will be arbitrated. It may take a day or 2, but 20 minutes later, the judgment came out. Get your money out. It's fabulous.
There you go.
It's just tremendous. That's what we need. Goodness knows what algorithm was operating there. We could cut through quite a lot of the backlog.
Well, I was doing crime at the time when you had those 55-year-olds, and by God, it was good, Ed, because you knew that the client was getting a fair deal. And everybody had their role to play, but I definitely felt that I played a part in something which I admired and on the whole was working properly. Whereas I can't imagine saying that now.
No, and I think we always also had, always had large miscarriages of justice, even in this classic adversarial era. But I think by and large, justice went better by having classic adversarial routes. So, the investigation, the lack of defence disclosure having to be offered in advance of trial. So you're not showing your hand in advance of trial, and you're testing the prosecution's case. And I think that's being done away with. I mean, the idea, to go back to the earlier question of what it's going to look like now, if you think about the early guilty plea and how many people plead guilty, I think in Q3 of 2020, only 8% of all cases were heard in front of a jury. So that's a not guilty plea at the Crown Court. That's a worry. We constantly hear of pressures of juries can't understand complex fraud cases because they go on too long and they're so complex they get bored and switch off, so therefore justice can't be done. Juries don't understand rape trials, and that's the reason why we have such low conviction rates. So let's do away with juries there. And again, if you do away with juries and just have professional judges hearing cases, you're going to be quicker. But are you going to be fairer? And I don't think you would be. And I think that sort of chipping away at this idea that jury trials are problematic is another sort of efficiency driver. It just comes in a different guise. We're just saying it doesn't work. Well, an acquittal is just as valid a verdict as a guilty verdict. Just because someone hasn't been convicted doesn't mean that the jury have been wrong. It means the prosecution did not discharge their burden of proof to the required standard. And there's nothing wrong with an acquittal. It's a perfectly valid response from the jury.
I think one of the best things to have come out of the post office scandal, if you can say, if you can put it like that, but there are several really wonderful lawyers that have such integrity, and it's a joy to know that they're still around, willing to do it for nothing as well. They're doing a lot of the work pro bono, but it's complete admiration for those people that will do it. And aren't we lucky? Aren't we lucky that they're around?
Absolutely, and in that similar vein, in Liam Allen's case, it was the prosecution barrister that discovered the text messages and then said, well, this is a problem. We need to we need to hand this over to the defense. But they found that late at night. It was 10 o'clock at night. They were working after hours on the case, and it was found by luck by that person's diligence.
And,
So
and the
yeah, there are
and
great lawyers out
the
there.
lawyers being totally honourable and doing the job. You know, not
Well,
saying, well, it's 5 o'clock, it's time for me to stop, or, you know, I haven't got
no,
time.
and I think by and large lawyers do respect the process, and they do a very, very good job. But I think the pressures that just surround them sometimes make it almost impossible to do a good job.
Is there an overall statistic about how many cases lead to acquittal? Do you have any sense of? I mean, I'm sure it's all different for different offences, but because I'm thinking there's some jurisdictions where, as I understand it, there's more or less 100% conviction rate.
Oh, absolutely.
I mean, Japan has been quoted with
Yeah.
the car director, guy who fled in the music box, the instrument box, because he said he wasn't going to get a fair trial in
Wouldn't get
Oh,
a fair
yes,
trial.
yeah.
jurisdiction.
No, I gave a talk to, it must have been 2 or 3 years ago now. I went to Kazakhstan to give a talk on disclosure, which was very interesting. And I sat in a room with, it must have been 100 defense lawyers and judges. And through the interpreter, I was asking them a couple of questions. And they were extremely proud of their 95% conviction rates. And I was like,
These are the defence lawyers. Very good.
yeah, yeah. So yeah, I mean, acquittal rates are low. I think in the magistrates' court at the tail end of last year, you're probably looking at, again, I haven't read it for a couple of weeks, but sort of 80%, 85% of all cases end in a guilty verdict. So acquittal rates in the magistrates' courts are rather rare. I don't necessarily have the Crown Court figures to the top of my head, sorry.
Mm. It may be a measure of how much justice people are getting, though.
I would imagine it would mirror close to the magistrates' court. I think it would be low, certainly less than 20%, and probably far fewer than 20% of cases.
Well, how depressing, Ed.
It's pretty bleak, and I think if you're accused of a crime now, you're in for a struggle. So be
And
good.
even more reason to be thinking, don't go to that police station without asking for legal advice if you haven't got it already. I mean, the duty solicitor system presumably still exists and somebody will come out for you. Don't fall into the trap of that, oh, they're not able to come for a couple of hours, so why don't we just get on with the interview? Never agree to that. Sit in the cell and wait. I know it's not very nice having to do that, but on the other hand, at least you're going to have a lawyer with you, and they do get to talk to you before you go in and be interviewed. So,
Absolutely, and they're completely impartial and independent from the police as well. And I think there's a misconception that they're a police station lawyer. And
oh, is
that's
that
not the case.
right?
From what I've heard and read, suspects are concerned that the lawyer is somehow linked to the police, and that's a concern. There are certain police forces. The work of Dr. Vicky Kemp has been excellent in the southeast of England in terms of police forces almost going through the custody officer going through a checklist of reasons of why you were rejecting legal advice, because they want you to have legal advice in that particular police force. I mean, any evidence sort of gleaned from a police interview is going to be more robust at trial if it's been gleaned in the presence of a defence lawyer. So it's in the police's interest to question a suspect in front of a lawyer.
Well, Ed, thank you so muit's been really
Thank you for having
enjoyable. Well, come back again and talk to us on some other topics, because really it's been a great interview. Thank you very much.